Hi guys, my name is Allison Grosz. I'm a partner and an attorney here at Hemrick O'Malley PLLC in New York City. I want to talk today about fiancé visas. I get a lot of questions from people about whether or not they can petition for their fiancé to come into the United States to get legal status prior to them getting married. There are a couple options about how you can get married to somebody who is an immigrant or an intending immigrant in the United States. Of course, people can get married outside of the United States and petition for their spouses or children to come into the United States with legal green card or immigrant status. I'm going to save talking about that for another video at another time. Today, I'm talking about when you don't get married before you petition for somebody to come into the United States to be your lawfully wedded spouse. The answer is yes, you can file a petition for someone. However, there are many requirements, as there usually is, and many rules and regulations that go into this. There's a very popular TV show here in the United States called 90 Day Fiancé. Of course, this is an oversimplified and entertainment version of a legal process that is called the K-1 visa process. Now, let's start with the idea that there are two different kinds of visas that a person can get in the United States. The first kind of visa is called an immigrant visa. Oftentimes, an immigrant visa is referred to as a green card. There's another kind of visa called a non-immigrant visa. A non-immigrant visa is any other kind of visa that doesn't have any permanent status attached to it. Now, when somebody gets an immigrant visa, they can get it from here in the United States, called adjustment of status, or they can get it from outside of the United States through what's called consular processing, or applying for your immigrant visa or green card through a U.S. consulate at a country abroad. The second kind of visa, the non-immigrant visa, is a visa application that anyone can make either here in the United States, also called a change of status or extension of status, or outside of the United States, which is any other kind of visa that somebody might want to use to enter the United States. Various visas that are non-immigrant are popular things like tourist visas, work and travel visas, student visas, other kinds of employment visas. The reason why I'm talking about all of these kinds of visas is because the K-1 visa, or the fiancé visa, is a non-immigrant visa, despite the fact that you are intending to bring your future spouse to the United States to get permanent status. This is a common term that we refer to in immigration called dual intent. This means that despite the fact that your fiancé will be coming to the United States on a non-immigrant visa, they intend or have a dual intent to come into the United States on the non-immigrant visa, which is temporary in nature. However, they plan on transitioning that to a permanent or immigrant visa or green card, which is permanent in nature. So let's talk a little bit about what needs to happen in order to bring somebody here as your fiancé. There are several requirements, as I previously mentioned. The first, that a person has to live outside of the United States. The second, that that person and you are legally free to marry. This means that any prior marriages between you or between either one of you with other individuals must have been legally terminated in the jurisdiction where either one of you live. The third requirement is that you have to have met this person. You have to have met them within the last 2 years before you petition for them to come under their non-immigrant K-1 visa status. You have to have met them within 2 years of you petitioning for them to come into the United States as your fiancé. Now, there are a couple caveats related to different kinds of marriage brokers and arranged marriages, and that's something that you will need to bring up with and discuss with your qualified immigration attorney if that situation applies to you. Another requirement is you, the petitioner, must have not been convicted of or committed a serious crime. The same goes for your fiancé. However, there are different requirements about criminal background for your fiancé versus you as the petitioner. Lastly, yes, you can petition for your future stepchildren. In other words, the children of your fiancé. They do have an option. However, they have to be children who are under 21 years old. And there are other certain requirements in order to be able to petition for your fiancé's children to come in under what's called K-2 non-immigrant status, which is a derivative child of your K-1 fiancé. Last, but certainly not least, there are several requirements that need to be met once your fiancé does come into the United States on their K-1 fiancé visa status. The most popular and the most well-known is, of course, that you have to be married within 90 days of your fiancé entering the United States. Once you get married, you can go ahead and file all your immigration paperwork. There is some paperwork that would normally be required if you were petitioning and filing for your spouse. However, since you're petitioning and filing for your fiancé, after you get married, you can skip a couple of the forms that you would normally have done for your spouse. I recommend speaking with and working with a qualified immigration attorney such as us here at Hemrick O'Malley PLLC. The reason why is because this is such an important part of your life and your fiancé's life. It's very easy to not understand the nuances. There are many steps to this process. It's not a single step process. It involves the filing of the petition. It involves your fiancé filing their non-immigrant visa application at a consulate abroad. It involves traveling into the United States and being married within a certain period of time. And it involves filing the correct paperwork after the marriage takes place. We here at Hemrick O'Malley PLLC love to work with people on their fiancé visas. We love to talk to people about their love stories. We can't wait to hear from you about this or about any other immigration matter. If you have any questions, you can always reach out to us. You can find us online at hemrick.law, or you can reach out to us at 833-848-7838. We can't wait to hear from you, and we look forward to helping you and your fiancé realize your love story very soon. Until next time, I look forward to talking to everyone then.